Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 22-5214. Advocate Christ Medical Center, also known as Advocate Christian Hospital et al., appellants, versus Xavier Becerra, Secretary, United States Department of Health and Human Services. Mr. Miller for the appellants, Ms. Marcus for the appellate.
Mr. Miller, good morning.
May we begin? May it please the court, Daniel Miller appearing on behalf of all appellants. This case presents the question of what it means to be entitled to supplemental security income benefits under the disproportionate share provisions of the Medicare Act. In 2010 rulemaking, the Secretary pronounced a policy on this very issue. And in that 2010 rulemaking, the Secretary declared a distinction between a person who is eligible, an SSI eligible individual under Title 16. That in itself is not enough to be eligible to be included in the Medicare Act, or the Medicare fraction of the DISH provisions. The Secretary said instead that in addition to being an eligible person, the person has to be entitled to receive a monthly payment from the SSI program in order to be counted. In our appeal, we contend that the Secretary's construction is too narrow. The construction the Secretary has utilized and that remains in place to this day disregards the congressional intent to include all SSI enrollees in the SSI portion of the Medicare fraction. And it's also inconsistent with the decision of the Supreme Court in the Empire case decided last year that concerned a corollary provision, which is entitlement to Part A benefits under the Medicare Act.
The statute, by its terms, defines the entitlement month to month.
The statute does indeed define entitlement to monthly payment under 1382C.
And your theory is that entitlement should be defined by reference to enrollment, which is a 24-month period, which is just the unit by which the agency processes, is the application still on file?
I don't think that's the status. We believe it should be maintained. It should be counted by who is an eligible individual under Title 16, which is defined in 1382A. I'm not sure what the 24-month enrollment is that you're referring to. A person can become eligible for Medicare.
I thought your theory is that, maybe I misunderstood it, but I thought your theory was anyone who's enrolled, right, has filled out the application, gets the benefit, and then income goes up, so that person doesn't get the benefit in the later month, but is still enrolled.
That's right. They are still eligible. The person has to apply for SSI, Title 16 Supplemental Security Income Benefits.
Okay, but that's the person I'm saying is not eligible under the statute for that month.
I would say that they do remain eligible, and this is why. Under 1382A, Judge, the person is declared by Congress to be an eligible individual for purposes of Title 16.
And in C1, the statute says eligible for the month based on the income determination, which varies month to month.
It says that they are then eligible for the monthly payment based upon an income determination that is actually not based upon the person's circumstances in that month, but on a prior month, either 1 month or 2 months previous.
Okay, but it's month to month.
It is month to month, and it can alter in some circumstances. But the important point is that Congress established who is an eligible individual, and a person does not lose their eligibility under Title 16 because they don't get a monthly payment. They remain a participant in the program.
So you want us to read entitlement to be eligibility and eligibility to be the statement in 1382A without reference to the month-to-month clarification in 1382C1.
Right. 1382C encompasses a variety of circumstances in which a person may qualify for a payment or may not qualify for a payment depending upon individual situations. But it does not undermine the person's continuing eligibility as an SSI program participant. They could get a payment 1 month, miss a payment the next month, and then receive a payment in the third month. So although there are payment limitations baked into Title 16, that is akin to the payment limitations that the Supreme Court considered in Empire and said that those do not disqualify a person from inclusion in the Medicare fraction.
Empire dealt with an insurance coverage issue, whereas now we're talking about a benefit. And it seems that the Social Security benefits are defined as cash benefits. So I think that that's an important distinction.
It's true. Empire is Empire concerned Medicare Part A, which is health insurance. The Title 16 program is essentially income insurance for the lowest income Americans. It's a safety net program that provides for safety net financial assistance to those most in need. So it is not health insurance, true, but it does function as essentially income insurance for those people that are most in need.
So the agency relies on the statute 1381A to say that these are paid benefits. And also there's a regulation 20 CFR 416.120, which says, as used in this part, supplemental Social Security income benefit means the amount to be paid to an eligible individual. How do you respond to that?
Because if you look at the regulations, 416.200 and on down, what they first established is a person has to apply for benefits and be determined to be eligible, which means that they meet the basic income and resource qualifications for the program. At that point, a person is enrolled in SSI and becomes an eligible person. It then goes on to describe the circumstances in which they can be eligible for a monthly payment. Those are two different steps. And if a person meets the monthly, if they don't meet the monthly payment criteria for a particular month, they remain eligible for SSI. That's what Congress intended in 1382A.
I think that's fine, but that doesn't mean that they're entitled to benefits for purposes of this fraction.
They're not entitled to the monthly stipend. That's true. However, there are other benefits that accrue to those individuals as well that remain in place whether they're receiving the monthly stipend or not.
But those other benefits, they're not under Title 16, are they?
Some of the benefits are the vocational rehabilitation benefits have been baked into Title 16 since the Vocational Rehabilitation Act of 1973. Remember that 85% or more of SSI beneficiaries are disabled. Disabled individuals qualify to seek voc rehab benefits, and those remain in place whether they're getting the stipend or not.
Sorry, I thought, is that the ticket to work benefit you're talking about?
Ticket to Work is a program. It's in Title 11.
It's in Title 11.
Security Act. That was created in 1999. That was a new iteration of voc rehab benefits, but it wasn't the creation of voc rehab benefits. The
Okay,
voc
so
rehab benefits,
where would we find vocational rehabilitation benefits in Title 16?
in Title 16, I'll provide you with a precise citation on rebuttal.
Okay.
But in Title 16, it is still the case that disabled individuals will be paid or are eligible to be paid for vocational rehabilitation benefits, even in months in which they don't receive the monthly stipend from the program.
So you didn't raise vocational rehabilitation services and Ticket to Work before the district court, did you? Aren't you forfeited?
That issue was not raised. However, other program benefits has been raised throughout the course of these proceedings, both before the provider board, before the CMS administrator, and before the federal district court. So there are other benefits in addition to vocational rehabilitation. For example, Medicare Part D subsidy. All SSI recipients get fully subsidized Medicare Part D coverage by virtue of their enrollment in the SSI program. That also is paid regardless of whether they're getting the monthly stipend or not from the SSI program.
So we'll take whatever Title 16 site you give for us and think about forfeiture and such. But
Yes.
the main the main other benefits that you rely on are ticket to work and Part D, automatic enrollment in Part D. But ticket to work is a Title 11 benefit and Part D is a Title 18 benefit. So why did those count as being under Title 16?
Well, vocational rehabilitation benefits are part and parcel of Title 16. One of the key elements of Title 16 is to return disabled individuals to the workforce. So if you review the regulatory provisions for Title 16, you will find copious information about not only their entitlement to vocational rehabilitation benefits, but also the fact that the agency needs to send them information about the right to seek vocational rehabilitation benefits. It is not correct to think of Title 16 as merely an income support program. One of the key initiatives of Title 16 is to return disabled individuals to the workforce. That's why these income supports come into place. Now, you mentioned again, ticket to work. That was created in 1999. And at that point, because Social Security administers not just Title 16, but also SSDI. So their voc rehab efforts do encompass both programs. And when they created Ticket to Work, essentially what they were doing was enhancing voc rehab benefits. They weren't creating them, they were enhancing them. The Voc Rehab Act of 1973 is the original source of voc rehab for Title 16. In Ticket to Work, essentially it was an effort to privatize those efforts to help disabled people return to the workforce. So they extended benefits to private companies that would be given a financial incentive to help coach people to get jobs, to give them job training, and to then help them find jobs and maintain them. So it's true that's in Title 11, but it's also true that it applies to Title 16 recipients as it does to Title II recipients.
Does your argument depend on our concluding that there is this vocational rehabilitation benefit above and beyond just the monthly paycheck, the monthly check, and that it is in Title 16?
Yes,
Okay.
our argument does rely upon that vocational rehabilitation is an independent benefit within Title 16 that attaches to SSI eligible individuals, those who are disabled. And again, that's 85% of them. But again, there are other benefits as well that accrue to those people based upon their enrollment in the SSI program. They get the Part D benefit. All of them get that by the Secretary's admission. That far more people receive that subsidy than are being counted in the numerator of the Medicare fraction at this time.
But if we didn't have vocational rehabilitation and we didn't have Part D, would you be making the same argument?
Yes, sir.
Based on 1382A?
Yes, sir. And I'd like to explain why, if I could. Even if you were to conclude that the only benefit is the cash benefit, and we would respectfully disagree with that conclusion.
I understand. So
But
this
even
is
if
your
you were to
alternative.
conclude that, if the cash benefit is the only benefit, in light of the Empire decision, the fact that a person doesn't receive the cash benefit in 1 month, but may receive it in the month before and the month after, still qualifies them to be counted. Because what Empire said is that limitations on payment do not disqualify a person. And the record before you is undisputed that when these individuals miss a payment, they are not kicked out of the program. They don't have to reapply for benefits. They remain in the program. If the work enhancement opportunity results in them, well, if the work enhancement opportunity results in them making too much money for a month, the very next month they may not make it. The other thing, they may not make enough so they would qualify again, I should say. Their benefits are reinstated automatically.
The reasoning of Empire, though, was very much dependent upon the statutory context, how that word is used within the Medicare statute. And the statutory context here is very different.
It's different. It's true, it's different. It's somewhat different, but you do still have benefits that remain in place, number one, with voc rehab and Part D and, for that matter, medical assistance benefits. But you also then have the opportunity, as Empire explained, in a justifying state, counting individuals who have what are called Medicare exhaust days. What the court said in Empire is, if the person has Medicare exhaust days, so Medicare did not pay for that care, the next spell of illness may be covered by Medicare. So if a person on SSI does not receive a monthly payment because they made too much money in their part-time job, they might get, the very next month, they might get that check. The other important thing to remember is the system that is in place right now does not measure the individual's eligibility month by month. The payment computation is based upon data from either 1 month or 2 months prior. So the information the secretary is using is not measuring the person's financial profile at the time they're hospitalized. So in our
Don't they
view,
do this whole payment at the end of the year anyway? And then they recode for people who change status later.
so the secretary acknowledges in their brief that their current system, I will say that their current system is internally inconsistent and leads to absurd results. Because number one, as you say, their rationale is, don't worry, we are not counting some people who are eligible. They acknowledge that, but we fix it later because we run the data 15 months after the fact. However, in doing that, it disregards the record, which is that many of these disputes about a person's disability or about a dispute about whether payment should have been suspended, it takes years, not months, to resolve those. So those kinds of problems are not going to be fixed by running the data 15 months later. The other problem with that rationale is none of the information is shared with hospitals. That is why a mandamus claim is a part of our complaint, because the information we need to verify and challenge our calculation has never been given to the hospitals. So the government says, trust us in terms of we're going to fix that later, because they acknowledge they're not counting all eligible people as they do these calculations, but they don't give us the information to test that.
Well, you're asking for the code information and they don't have the code information. SSA has the code information.
But they receive the data from SSA.
Not in that form though.
But the
according to the record.
secretary,
Go ahead.
I'm sorry, respectfully, the secretary can get the information it needs from SSA because they're getting it now. They can direct SSA. It's the secretary's duty to get the appropriate data information from Social Security Administration.
So I think the secretary is getting what they think is necessary, but they're not getting what you think is necessary.
And they're not sharing any of the data with hospitals. None of the
Well, they're
Medicare
sharing the data that they think is necessary, but they're not getting additional information that you think is necessary.
But the data they share is not adequate under the Medicare Modernization Act, because we are supposed to be able to verify and challenge the DISH calculation. None of the codes, either for the patients they're counting or for any other patients, are ever provided to hospitals.
Codes are not provided to HHS. SSA gives it to them in a different form.
I
So
believe that,
you're asking them to give you information they don't have.
but it's within their control to obtain the information, and it's within their obligation to obtain the information.
All right, Mr. Miller, we'll give you a couple minutes in reply.
At this point, we're on rebuttal. Rebuttal?
Yep.
Thank you.
Ms. Marcus?
Thank you, Your Honor.
You
Good
wanna
morning. Oh,
Put that microphone down or the podium.
is this better? Can you hear me now? Okay, thank you. Good morning. I'm Stephanie Marcus from the Department of Justice, and I represent the Secretary of HHS. In this case, the district court properly upheld the Secretary's interpretation of entitled to SSI benefits under Title 16. That interpretation best reflects the plain language of the statute in the context of the benefits program to which it refers. And as Judge Katsas and Judge Pan have recognized, there are elements of the SSI program that distinguish it from the Medicare program that was addressed in Empire Health. And one of the main ones is that the SSI program is a cash benefit program that does vary. And so that a benefit varies and eligibility or entitlement to that benefit varies from month to month based on income and resources. That's different from Medicare, which is an insurance program. And you are covered by the insurance. And that is once you reach age 65, as the Supreme Court said, that's a status-based benefit. It doesn't change. In
Your
addition,
friend says there's a vocational rehabilitation benefit in Title 16. I had sort of written off Ticket to Work because it's in Title 11, but you want to address, I know you're shooting in the dark here because we don't have the site, but what's your understanding
we did
of?
have only one statutory site in the opening brief, which we refer to on page 35 of our brief. It's in footnote 5, and the sole site plaintiff had.
I'm sorry, what page?
This is on page 35 and it's
Of the red brief?
of the red brief.
Is 1382D?
Yes.
And sorry, which title is that?
Oh, that is the only, believe that is Title 16, but it applies to referrals by the commissioner of individuals under age 16 to the appropriate state agency administering the state program, and allows for reimbursement to such state agencies. So we are relying on what Congress said the basic entitlement under Title 16 is, and that's set forth under 42 USC 1381A. And it refers to benefits paid by the commissioner. And then the plaintiff also referred to a number of regulations about vocational rehab services, but those need to be looked at in the context of the Secretary's longstanding Title 16 regulation under Title 16, which, as Judge Pan pointed out, defines supplemental security income benefit means the amount to be paid to an eligible individual. So and there's a Ticket to Work provision that we cited that also defines the Title 16 benefit means a cash benefit. We have that, it's a cite in our brief. It's
For purposes of the section in Title 11.
Yes, but I mean, so we have the Title 16 provision itself, a provision from the Ticket to Work program that also applies to vocational rehabilitation services, and a regulation from the 1970s. And all the court needs to do is determine that the Secretary's interpretation is at least permissible here. And we submit that because of the nature of the SSI benefit program, the interpretation is entirely consistent with the Supreme Court's Empire decision.
Can we talk about cross-program recovery? Because that seems to be a little unclear in the record. Do you know how that's coded?
Your Honor, and we will, as we said in our brief, we don't think that's really properly considered in this case, but we did, after more discussion of it in plaintiff's reply brief, we did inquire with Social Security, and our understanding from Social Security is the code remains the same. So if the person,
So what is
This is E101, sorry.
it's not EO1, as we said that,
EO1.
if someone has a payment, is entitled to a payment, that's the only way you could get cross-program recovery.
So that it's included within CO1, MO1,
Yes.
or MO2?
And yes, that's our understanding from Social Security. And we also would refer to the statute cited by plaintiff about cross-program recovery itself shows that the agency, if they're going to do the cross-program recovery, which I think, again, I don't think applies to any of the patients in this case, and it wasn't, is not relevant to the rulemaking or the actual statutory interpretation, but putting that aside, they would only take the lower of 10% of the person's income or the benefit. And because the benefit is included in the person's income, our understanding is that they just didn't know of any cases where the whole benefit would be taken anyway, or it would be rare because
So
of the
I guess
income
you're saying,
limits.
I see.
Yeah.
Are you saying that they don't know of any cases where it's reduced to zero? And if it's reduced only somewhat, then it would be a
Yeah,
payment?
it theoretically could be, but they also said that the code remains the same.
Meaning it's within CO1 or MO1 or
Right.
MO2?
And again, as we noted in our brief, the EO1 wouldn't be logical in that situation because EO1 is when the person isn't, entitled to a payment for that month, either because the application has not become effective, and those people are not entitled to a payment, and that application is yet another reason that this is distinguishable from the Medicare program. You have to apply. Just being an eligible individual under the standards isn't enough unless you actually apply and your application is granted. The other one is if the person is in a medical facility and there's a limitation on payments for that. And if the income exceeds that, they're not entitled to a payment. So that person wouldn't have anything to recover from in cross program.
So sorry, just to make sure I got this. You are representing to us that a person who is entitled to a payment in a particular month and doesn't get it because of this clawback thing.
Okay, and we are not aware of any
would not
of
be
that
coded,
happening. Yeah.
would not be coded in EO.
That is our understanding, Your Honor, but again, I don't
I mean, I
think you need to.
thought that's what you were saying in your brief, but it wasn't that clear.
It's because it's not in the record, it's not properly in the record in this case, because the program was not, in this case, plaintiff hasn't developed any examples of this happening. And because our understanding is also that it is virtually always going to be limited to that 10% of income, and that person will still get a payment for the month.
It just might
So
be reduced. But
then
they'll
there
get
wouldn't,
something.
yeah, then it would still be CO1, but it would be a lesser amount.
And when you confirmed with the SSA before argument, did you ask them about EO1 or?
We asked them about what the code would it change the code if like in the cross recovery program. And again, this was just in discussions, and this is our understanding. And I think, there's, again, if you look at what EO1 means, it makes sense. That's what we said in our brief. And this case is about the reasonableness of the Secretary's interpretation and how the Secretary interprets the statutory language. This plaintiff isn't asking to go back and look at, what happened to individual patients or anything. And here we are saying that
It's mostly about that, right? But they have a fallback argument that even under your interpretation, their coding doesn't operationalize things in the right way because they put these people in EO1.
right. And we would refer the court then to the rulemaking where the Secretary went through in the rulemaking on addendum page 18, the Secretary addressed a number of codes that commenters had brought up in the rulemaking. And the Secretary went through and explained what those codes were and said why they weren't within the statutory interpretation of entitled to SSI benefits under Title 16. And that's because under the Secretary's interpretation, it means entitled to receive a cash benefit while the individual is in the hospital. And as plaintiff acknowledges, that doesn't mean that the person actually has to get the cash that month. There is, as the rulemaking shows, a 15-month period where SSA may be developing, why the person, there could be an appeal. They may be figuring out whether the person actually is eligible, and they will retroactively change the code. And so it's just whether they're looking, the HHS in determining the disproportionate share percentage is looking at whether the person was entitled to receive payment that month, not whether he or she actually got a payment.
Can I ask, so suppose we agree with you that enrollment is not sufficient you have to look to entitlement to the cash benefit on a month-by-month basis. But I still wonder whether, and that means your opponent's interpretation is wrong, but under your interpretation, you don't count people who are unenrolled for whatever reason, but who meet all of the status-based and income-based requirements for the program. Someone who's elderly, someone who's disabled and has no income, right? And they just haven't gotten around to enrolling. Wouldn't we say in plain English, like that person is entitled to the benefit and like just hasn't filled out the paperwork?
No, Your Honor.
And isn't that person the kind of person Congress had in mind, because that person is poor and has the health complications that come with it, which is what drives this fraction?
Your Honor, I think that question actually points out the problem with the plaintiff's interpretation about, anyone eligible or enrolled, but not actually entitled to receive benefit for the month should be included. And the statute itself shows that that's not what Congress intended to be entitled to the benefit under Title 16, because in 1381A, it says every aged, blind, or disabled individual who is determined under Part A to be eligible. So that also refers to Part 42 USC 1382 C7, which is it's a statutory, not a regulatory requirement that the person apply. So I would submit that Congress didn't think a person in, just someone who's sort of eligible out in the air.
Yeah, I mean, I see that, but on the other hand, it's not applying like, in some competitive process, applying to an elite college or something. You submit the application and it seems pretty pro forma. C7 says the application is effective on the first day of the next month after you've become eligible and applied. It just seems like this is a matter of paperwork. And just one other thought on that, which is like just sort of the concept of entitlement. In this program, Congress appropriates whatever funds are necessary to meet the program, which often is associated with the word entitlement.
Well, Your Honor, I think with the application, it's not pro forma because of the income and resource limitations. And there are issues, such as your spouse's income and resources count in that too. So there are a lot of inquiries the agency needs to make. And in determining whether the person actually is eligible. So even someone who may think he is, under the income limit, if his wife owns some, a piece of property that would disqualify them, then, it's not pro forma, and it is the entitlement to the actual cash benefit wouldn't actually vest until the application is. And if there are no further questions, we'll just rest on our briefs on the mandate. Thank you.
All right, thank you. Mr. Miller, why don't you take 2 minutes?
Judge, the citation you were looking for is 42 USC 1382H.
1382H?
Yes, sir.
Okay, we'll check it later. Thank you.
The Secretary's interpretation of the statute conflates two terms, eligible and entitled. And in case after case, that distinction has been rejected. It was rejected.
That's true, but so does 1381A, whose title is Basic Entitlement to Benefits, and all of whose text it talks about eligibility.
Indeed, and as Judge Henderson observed in the Hall case in this circuit, Those two terms are synonymous.
I'm sorry.
Those two terms are synonymous, eligibility and entitlement. In the Supreme Court case of Empire, they rejected Empire Health Foundation's attempt to try to draw a distinction between eligibility and entitlement. What the court said in Empire is that if you meet basic program qualifications, you should be counted in the dish fraction. And in this case, what that means is the court should follow the congressional definition of who is an eligible person for purposes of this title, which is in 1382A. The secretary acknowledges that he is not doing that. He is taking a subset of those individuals. Only those who receive the monthly payment are being counted. And so if I have 40 seconds left, what I would say is the system that is currently in place is arbitrary and capricious as the terms are used under the Administrative Procedure Act, because again, the decision is being based upon the individual's financial profile from 1 or 2 months prior to the date of hospitalization. The system that they're currently using counts 3 codes, 2 of which include people who are not eligible for payment, and many of the codes being excluded are for people who are in fact eligible for payment. So in our view, the system that they have in place should not stand. It's also, to us, the idea that they're using a subset of people for purposes of the Medicare fraction numerator, but all SSI enrollees receive the Part D benefit is another illustration that it's not a reasonable interpretation of the statute. Are there other questions for me?
I don't think so. Thank you.
Thank you very much.
Case number 22-1262 et al. Longmont United Hospital petitioner versus National Labor Relations Board. Mr. Scully for the petitioner, Mr. Colton Batt for the respondent.
All right. Mr. Scully, good morning.
Good morning. May it please the court. My name is Patrick Scully, and I am joined by John Melkin this morning, and we represent Longmont United Hospital. Your Honors, employees and employers rely on the integrity of the National Labor Relations Board election process, as it has been an element of labor law that has mostly escaped the political vacillations that usually accompany a change in administration. Bright line rules ensure security in that election process, and they have been historically applied without regard to the identity of the voter or the outcome of the election, except in this case. The board has improperly adopted Member Stevens' dissent in Thompson Roofing, and thereby invited post hoc litigation of the issue of whether a voter has put her signature on the envelope of a mail ballot. The mischief of this departure is that, and it is a departure from established precedent without reasoned explanation in our view, is that parties are thereby invited into a process whereby they will litigate the subjective intent of the voter in a way that is contrary to not only established precedent of the NLRB, but of this court.
Is it litigating subjective intent, or it's just litigating the fact question whether the voter signed the envelope?
Your Honor, we believe that it's not a fact question, but a legal question, in that the board, since Thompson Roofing, has held that the mail ballot voter must put her signature on the ballot and has rejected.
Okay, so then the question is, did the voter, is this Miss Shalaman's signature?
No.
Is this her signature?
Your Honor, the question is how that issue is determined. And by the use of exemplars, as we noted in our brief, there are 16 exact exemplars of her signature. And our position is that the decision should have been made based on that without post hoc litigation having the voter, for instance, verify that this is indeed my signature.
And that would seem to be the best evidence of whether or not she signed the envelopes. Her testimony that she did or didn't.
Well, that testimony, Your Honor, occurred after Ms. Shalman also testified that she had conferred with the petitioner, the petitioning union in this case, and had been advised that her vote would in fact determine the outcome of the election. And whether or not that's true, that demonstrates the mischief of litigating this. The point is historically the board has simply looked to exemplars of signatures and declared as void if the ballot was not signed. And without regard to how we define printed, in this case, Ms. Shalman, in fact, wrote her name in the way she had printed it on the exemplars that we provided in the course of the investigation and also cited in our brief.
I'm trying to understand your position, counsel, but you seem to be saying that if there's a disputed factual issue, there shouldn't be a hearing to determine the fact. And that's unusual in my view.
Yeah, Your Honor, our position is that it's a legal issue whether or not it was the signature. I don't think that there's any dispute in the record here, as acknowledged by the hearing officer and the regional director, that the writing on the ballot envelope in this case does not resemble Ms. Shalman's signature.
But I think the disputed factual issue was whether that was her signature, and she ended up testifying that she signs things fast sometimes, and she has a different signature when she's taking her time, and that doesn't seem incredible to me. I'm just having trouble understanding. You just think the entire process of having a hearing is incorrect. You want us to hold that we shouldn't have hearings to determine factual issues.
No, Your Honor. What we're contending is that the board determined this factual issue when the hearing officer and the regional director said that the signature on the mail ballot envelope did not resemble this individual's signature. What was offered after the fact, and I think a hearing.
But if it doesn't resemble, doesn't mean that it wasn't her signature.
Well, I think it's fairly clear on the record that it wasn't because it doesn't match the prior exemplars, and I think that a hearing can occur.
But there could be an explanation for that. And you're saying we shouldn't be allowed to seek an explanation?
No, all we're suggesting is that the parties, when there's a hotly contested election and there's a slim margin, as there is in this case, that certainly the parties, whether or not we agree in this case that all of what was introduced was truthful or not, it demonstrates the mischief of litigating it after the fact because.
But if the board had ruled against you, you would have wanted a hearing to prove your side of it?
Actually, Your Honor, most of these cases are the Starbucks case and certainly Thompson Roofing involved contentions by employers saying that this individual's ballot should be counted and they shouldn't be disenfranchised when there wasn't a signature, when there was no dispute about the person validly submitting the ballot.
I guess my point is just it could go either way, and whoever is on the wrong side of that should be allowed to have a hearing to make sure that this was correct.
Well, Your Honor, we agree it could go both ways, and I think that that's the importance of having a bright line rule. And that's why the board recently in the dual mark ballot cases in Providence Portland Medical Center spoke of the fact of having a bright line rule to simply void any sort of dual markings rather than litigate the subjective intent of the marker of that, which led to results in those cases over years upon years where the board was litigating whether or not an individual intended to make a smudge or a line or an X in a ballot. And I think that that demonstrates really what the issue is in this case, that we have exemplars. They certainly, it is a distinctive mark. The board recognized that. And then after the fact, there was a hearing in which one of the interested parties spoke to the individual, prepped them, and had that person post hoc verify a signature that did not look anything like any of the other signatures that were in the record. And I think that that's why ballots get voided, is so that there isn't this constant litigation of what the purpose was in making a particular mark.
Suppose you have exemplars and then there's a signature and it's a nice, distinctive, elaborate signature. And then there's something much less distinctive, messy. And the voter wants to make a proffer that she had a stroke, which has affected her motor skills. And, make a further proffer that here's the video recording showing her doing her best to sign
I think in
the
that,
envelope. She couldn't do that.
well, in that case, Your Honor, all we're contending is that post hoc litigation is inappropriate. So anything up to the point, our point is that the moment that the mark is made, that it should be a signature, and the board has repeatedly held that if it's printed in any way, that it is void. So in that case, Your Honor, an individual would have had the medical condition prior to marking the ballot, and there wouldn't be sort of this after the fact.
Right, but if you just compared the signature to the exemplar, it would look totally different.
Yes, Your Honor, but there would be evidence prior to the time that the person cast their ballot, which I think is the critical time for all purposes in voting at the NLRB.
Oh, so you're saying there could be a hearing, but they can't admit any evidence after the marking of the ballot?
We're suggesting, Your Honor, that of course there could be a hearing, but to verify the exemplar, to verify that it was the signature at the time that it was signed. In this case, we had a post hoc photograph of a statement that purported to verify the writing on the ballot, which looked quite similar to the printed.
Didn't they admit other signatures by Ms. Shalamon from before signing of the ballot that also didn't look like the ones that you admitted?
None of which were claimed to be her signature. They were insignia on two different documents, which were, one of them was admitted not to be her signature by the witness, and also another that did not resemble the writing on the mail ballot envelope.
Mr. Scully, can I ask you, would you have been satisfied if instead of being asked baldly, is this your signature, which is the whole issue in the case, and she said yes, if she'd been asked, did you make the entry on that ballot?
I'm afraid I would not, Your Honor, because that is really the point of Thompson Roofing, which the board has disregarded, is that the identity.
Well, that is a fact as opposed to what she intended as either a signature or printing.
It is a fact that she was the voter, and we do not contest that for the purposes of this appeal, but that was the case in Thompson Roofing as well, and many cases decided by the board that the voter in fact cast the ballot, but it was not signed, therefore it was voided.
So she couldn't even be asked, in your interpretation of the rule, did you put that mark on the ballot?
I think that certainly the witness could be asked that, but we don't believe it should be determinative, that really the question is not the identity of the voter or whether or not they voted, but whether it was signed. And again, I believe that the board is arguing about that very issue, that really the key issue is, did this person cast the ballot? And we're saying that may be a rationale, but the rule has to be a bright line rule in order to avoid this process effectively that we're in. And I would have to accept the other side of that issue, Your Honor, if in fact the board had said, well, this is a signature based on the exemplars up to this point.
You're not contesting that Ms. Shalaman made the marking that I'm looking at here in a yellow box.
That's correct, Your Honor.
And you're saying there's a distinct legal question about whether that marking is sufficiently in cursive to count as a signature.
Well, there's a distinct legal question as to whether or not that was signature. And the legal question is really why the board departed from its established precedent in Thompson Roofing without reason explanation. Again, the board could revisit this issue and explain why that it is no longer going to apply a hard and fast rule with respect to signature. They didn't do that in this case, and that is why we brought this petition.
All right, we'll give you a minute to reply.
Thank you.
Mr. Altenbeck.
Good morning, and may it please the court. Mark Kaltenbach for the National Labor Relations Board. The board requests that its order against Longmont United Hospital be enforced in full. I'd like to begin by talking about the challenge to Nurse Shalamon's ballot. Longmont challenged the ballot at the vote count on the basis that it did not match signature samples in Longmont's possession. The question is whether the board abused its discretion in overruling the challenge, and it did not. The board found, and Longmont doesn't dispute, that Nurse Shalimon did cast this ballot. So any concerns about impersonation or fraud were resolved. Any concerns that might have been raised by the mismatching samples. Under board law, this is dispositive. This alone is dispositive. But Longmont argues that the board still should have disenfranchised Nurse Shalimon if she did not sign it in some kind of formalistic or technical sense of the term sign. Longmont's wrong on the law, but it doesn't make a difference in this case. Nurse Shalimon credibly testified that she did sign the envelope. So even accepting for argument's sake that there is some kind of technical signature requirement, it's met here.
Why do you keep saying technical and insignificant? The whole point of having a signature rather than a printed name is so that everyone knows that voter. It's just like when we vote in an election, we have to, well, back in the day when we had paper ballots, we couldn't print our name, we had to sign our name. When we register, we have to sign our name.
Yes. Yes, Your Honor. No, I don't mean the general requirement is technical or insignificant. It is a very important requirement that the board has had at least since the 1940s and probably for its entire practice. The point is the purpose of the requirement is to preserve election integrity. Okay, so the board requires the signature on the ballot envelope in mail ballots specifically so that this comparison can happen. And in this case, the system worked, right? There was a signature, non-printed signature on the ballot. At the ballot count, it was presented to the parties. The employer noticed something potentially concerning in the form of they had a sample in their personnel file that didn't match. So the board allowed the challenge to go forward and conducted a hearing to make sure that the integrity of the election wasn't compromised. So this is the system working, but my only point is it is undisputed that the integrity of the election was not compromised. Yet the company wants to create this distinction between a non-printed cursive name and some kind of nebulous technical thing that is a signature that is different from a cursive name. That's what I mean when I use the word technical. I apologize if I gave the impression that the board doesn't consider this general requirement very important. It does.
Well, I agree with you in this case because there's no question as to her identity. She was Miss So-and-so and she cast that ballot. But the issue is whether she signed it or printed it.
Respectfully, Your Honor, I disagree.
You don't disagree. Well, what do you disagree with?
I disagree that is the issue. In the reply brief, we were a little bit puzzled by what Longmont was asserting. In the reply brief, they made clear that their position is not this was a printed name. Their position is that it was not a signature. If you see the distinction, we're according to Longmont's argument, we're not in a binary world. It can be non-printed, but also not a signature. If they were arguing it's a printed name, which they clarified in their reply brief, they are not, that would be a different issue. I think it would be resolved by simply looking at the base of the envelope. When the board talks about printed names, it uses the ordinary, it means that in the ordinary sense. It basically says if you have printed lettering, that doesn't create the security measure that I just alluded to. It's not distinctive enough to satisfy.
Sorry, I'm not sure what class of cases we're talking about. If you assume that this is Miss Shalimon who made the marking, and you also assume that we're not dealing with something that is to printed, what are we talking about? What's the thing that could not be her signature?
I think it's a great question, Your Honor. We don't know.
You're not sure.
Yeah,
either.
Longmont's position is that there is some third category. So this is kind of related to this line of questioning. I just wanted to briefly talk about Thompson Roofing and explain the holding of that case. The point of Thompson Roofing, that is the board affirming a pre-existing practice of voiding mail ballot envelopes that come in that have undisputed printed lettering in them. That is the point of Thompson Roofing. That the practice existed. It was in the case handling manual. The question came up whether the board would endorse that, and in Thompson Roofing it did, saying that basically printed lettering isn't useful to ensuring us of the integrity of the election. Again, everyone agrees we're not in that. I believe everyone agrees we're not in that situation here, and I would argue that looking at the ballot envelope makes clear that we're not in that situation here. This is not a printed name. So what we have is, in this case, a non-printed name written on a ballot envelope, and one party saying, this doesn't match a sample. There's a concern that maybe there was some funny business here. That brings us into the world of the college bound case, which is a recent case from 2021, addressing very similar facts. In that situation where that concern is raised, if the ballot in question ends up being potentially dispositive of the election, the board conducts a hearing to see, is there anything to this concern? Is there anything to this suspicion? And in this case, that's exactly what they did. And they found that there wasn't. It turns out that there wasn't any impersonation or fraud, and no one disputes that here. I also wanted to briefly touch on and I'll note, by the way, that Longmont just ignores college bound in its reply brief, even though it is the case most on point here. I wanted to briefly respond to something that was said in the reply brief and that was again said here, which is, I think, somewhat of a mischaracterization of the documentary evidence in this case. Longmont repeatedly says that there are these 16 signature exemplars and they don't look like the ballot envelope and they basically say there's nothing else. That is not true. The driver's license, the nurse in question, Nurse Shalamon's driver's license was produced actually by Longmont pursuant to a subpoena introduced by the union in the representation proceeding. That driver's license establishes two key facts. First, it does not resemble the signature exemplars that Longmont cites, and so that at the very least establishes that this nurse has more than one version of her signature, at the very least. But the regional director in a footnote found, I think reasonably found, that if you actually look at that driver's license, the style is very similar to the one on the ballot envelope. So beyond establishing multiple versions, it also shows that corroborates your testimony that, hey, I wrote this. This is how I sign my name when I'm not in a hurry. The significance of that is that it corroborates Nurse Shalamon's testimony and supports the board's determination to credit her.
How about this Social Security card? Didn't she testify that she didn't write that one?
So her testimony with regard to the Social Security card, which I'll note, Longmont mentions the Social Security in its reply brief for the first time. It didn't mention it in its opening brief, so I think we would argue that it's waived. We didn't get a chance to respond, but her testimony on the Social Security card is very unclear and confusing. The regional director analyzes it in I think in a footnote in the regional director's decision, which the board affirmed. She doesn't clearly, she does say it's not her signature, but she doesn't really explain. The regional director basically found that the testimony wasn't enough to overturn the hearing officer's credibility resolution of her, particularly given the corroborating testimony regarding her driver's license and also the fact that the hearing officer got to watch her testify and observe her demeanor. Our position would be any concerns raised by this Social Security card testimony wouldn't be enough for this court certainly to reach into the representation proceeding and reverse that credibility determination, given the extraordinary deference the court gives to those kinds of determinations. Right. I see I'm over time. The board requests enforcement of its order in full. I thank you very much.
Thank you.
Thank you.
Mr. Scully, why don't you take 2 minutes and why don't you begin by saying or by answering his comment that you changed your position in the reply brief with respect to the third. It's not a print. It's not printed. It's not signed. What is it?
Thank you, Your Honor. Happy to do that. What we contended in the reply is simply that to be printed, it doesn't have to appear as block lettering, which is the position that the agency took. In the 16, not one exemplar, but 16 exemplars, most of them included a space for Ms. Schauman to print her name. And we submit that the printing on those is much like the writing on the ballot envelope. So we merely explain that we're not saying that printed means block lettering. It's clearly not block lettering, but it is how Ms. Schauman had previously printed her name. With respect to the
I'm
social...
sorry, so your position is that the ballot that is before us is printed?
Correct, Your Honor.
So
And
to
then
rule
not
in your
signed.
favor, we'd have to find it printed.
That it's not signed, I believe, Your Honor, under the board precedent. And I just wanted to
So
address...
are there only two possibilities, signed or printed, or is there a third possibility?
I think that the only rule that the board has promulgated is that there must be signed. It's never said that the objecting party or the challenging party has to prove that it was printed. The board has only said...
Okay, so if we look at this marking and we think it's a signature, you lose?
Well, I think that the hearing officer and the RD said that it didn't resemble these exemplars. So I don't think that that's the proper conclusion. I think the issue in this case is what is the rule of law at the board. And I think that...
I'm
Yes.
confused though, because if it's a signature and Ms. Shalamon did it, isn't that a good ballot?
But I think, yes, indeed, Your Honor, but I believe that the record demonstrates that it was not her signature. And I think that the exemplars demonstrate that. And I just want to, if I may...
So, but then we're back to, is there a third category? Because if it's a signature and it's hers, it seems to be a good ballot. It's not block printing. So is there some third category you think this is?
Well, I think that there is in the way that Ms. Schauman printed her name in the exemplars, Your Honor. And in those, there is cursive lettering where she printed her name. And so I think in this particular case, the manner in which she printed her name looked exactly like what appeared on the mail ballot envelope. And if I may just have a minute, Your Honor, with respect to College Bound Dorchester, which counsel addressed, that did not overturn Thompson Roofing. And
It's not inconsistent with Thompson Roofing.
Pardon me?
It's not inconsistent with Thompson Roofing, is it?
It did not overturn it, and it's not. And I think that in all of those cases where the board had voided ballots for non-signature, the parties always had argued, in most cases, the petitioner had argued that the ballot was cast by an eligible voter, so that there's no fraud, but the board nonetheless voided the ballot. And so with that, we'd ask that this order be vacated, and for all the reasons stated in our briefing. Thank you very much.
All right, thank you.
Thank you.
Case number 22-1139 et al. Concerned Household Electricity Consumers Council et al. Petitioners versus Environmental Protection Agency. Mr. McDougall for the petitioners, Mr. Link for the respondent.
Mr. McDougall, good morning.
Good morning. May it please the court, I'm Harry McDougall, representing the petitioners. With me is my co-counsel, Francis Minton of New York. We petitioned the EPA for rulemaking with respect to the 2009 endangerment finding. And with our petitions and supporting material, we demonstrated that the 2009 endangerment finding is based on a house of cards.
Could you start with standing?
Yes, Your Honor. There are two elements. As petitioners for rulemaking, we're entitled under Mass versus EPA to file the appeal. With respect to injury in fact, our injury is that the endangerment finding legally requires greenhouse gas regulation comprehensively, not just the electric power sector, and that drives up electricity prices.
So the endangerment finding talks about the contribution of new motor vehicles and new motor vehicle engines to greenhouse gas air pollution. How is that related to your asserted harm about electricity in your home?
Because the 2009 endangerment finding touches off a regulatory cascade or tsunami that drives regulation throughout the Clean Air Act, with the exception of the areas carved out by the UR decision. Other endangerment findings under other parts of the Clean Air Act rest and incorporate the 2009 greenhouse gas endangerment finding. And the position of the EPA is that they are obligated to regulate greenhouse gases due to these endangerment findings, including in every such rule a reference to the 2009 endangerment finding.
Could you point us to one such regulation you cited in the blue brief?
We did not cite a particular regulation in the brief, Your Honor. The legal obligation of the EPA to regulate greenhouse gas emissions as a result of the endangerment finding is undisputed. The evolution of the rules that carry out that obligation has been in fits and starts since 2009.
I mean, what you're saying makes intuitive sense to me at 200,000 foot level of generality. But I mean, I don't know how the endangerment finding compels the tailpipe rule, which compels Lord knows what else. And that's your job to spell out for us.
Okay. So, for example, the new source performance standard for the methane rule is predicated on a 2009 endangerment finding in part. And I know that these rules are no longer in play, but the Clean Power Plan also was predicated on the 2009 endangerment finding. The ACE rule was predicated on the 2009 endangerment finding. The new source performance standard for electric power units from 2015 was predicated on the endangerment finding. The 2016 aircraft rule under Section 231 was predicated in part on the 2009 endangerment finding. And the court has ruled in American Lung Association versus EPA that EPA is obliged to regulate greenhouse gas emissions from the power sector. But the regulations are not that drive electricity prices are not limited to the power sector. EPA also comprehensively seeks to regulate the fossil fuel industry at every point of regulatory contact, from exploration, extraction, transportation, refining, and consumption. And this constrains the supply and drives up the price of everything that uses that energy, including electricity. Most of the electricity in the United States is generated from fossil fuels. So the effect is manifested through the entire scope of regulation that ultimately rests on the 2009 endangerment finding.
So weren't you required to submit an affidavit to provide evidence to support your standing? I don't see such an affidavit in the.
I don't, Your Honor, I don't believe there's a categorical requirement for an affidavit. We need to demonstrate a plausible, a reasonable basis for the injury that we claim.
Well,
And
I believe there's authority of this court that says you can't do that in a brief. There has to be evidence.
In our original petition that we filed more than 6 years ago, we have an entire section on standing where we articulate our argument about why greenhouse gas regulation drives higher
Is
electricity
that evidence
prices.
or just argument?
Pardon me?
It has to be evidence.
There are categories of cases where evidence is required, and there are categories of cases where the allegations and the record and the legal requirements on the regulating entity are sufficient to demonstrate.
Can you tell me what authority says that it doesn't have to be evidence?
Well, the Spokio and Laidlaw discuss that the quantum of proof varies according to the procedural posture of the case.
But if we need a quantum of proof, that implies evidence.
We have supplied the court with real-world evidence that every jurisdiction that has tried to regulate greenhouse gas emissions from the electric power sector has experienced significant price increases, particularly when they move to renewable energy. So we have real-world examples: California, UK, Germany, and elsewhere that are experiencing. I mean, California prices are 3 times what they are in the rest of the country because of their commitment to replace fossil fuel power generation with renewable sources. And the reason that that's so is that it requires a much higher capital investment by the utility to overcome intermittency and low capacity factors. And that has to be recovered from the ratepayer.
I mean, I just want to finish this thought, which is, what is the authority that says that you don't have to file an affidavit, that you can just rely on things that you state in your brief?
The rule says the petitioner may file affidavits. It doesn't say the petitioner must file.
Well, it's your burden to show standing, so you may, but if you don't, you might not meet your burden.
That's the risk. I agree, Your Honor. And we believe that the combination of the legal compulsion to regulate greenhouse gases comprehensively, combined with the real-world examples that we provided, where power prices go up significantly when such a program is undertaken, suffice to carry that burden.
The usual case where you don't file an affidavit is where the party before the court is the regulated entity. It's the object of the regulation. But the Supreme Court has said that standing is substantially more difficult when the theory of causation depends on the actions of third parties not before the court, which is this case.
That's right.
I mean, you all are consumers of electricity, not the power generator.
Right. But I mean, we can take notice that EPA's position is that it must regulate greenhouse gas emissions comprehensively everywhere that they're able to do so under the law, that they are obligated to do so. And the current posture we're in with respect to rulemaking is that a new replacement for the Clean Power Plan and ACE rule is forthcoming this spring. EPA's position is not that they're not going to regulate. They are going to regulate. They proposed a rule Wednesday this week to require 2/3 of new cars to be electric by 2032. And if that happens, that increased demand for electricity will naturally cause prices to increase. So we're in an environment where the government is not saying they're not going to regulate. They're obligated to regulate. We don't know the exact form that that's going to take, but it's impossible to know that. But it's plausible. It's substantially plausible to expect it's what happened everywhere else in the world this has been tried will happen here as well. Now, on the merits, I'm down to 35 seconds, Your Honor. So would you like me to address the merits? Would you like me to sit down?
Well, why don't you sit down and we'll give you a couple of minutes and reply.
Okay, thank you. Well, at that point, I'd like to address the merits. I don't want to be foreclosed from doing so for not having brought it up now. Okay, thank you.
Understood. Mr. Link.
Good morning, Your Honors. I'm going to lower the. Good morning. My name is Brian Link from the Department of Justice, and I'll present argument on EPA's behalf. With me at table is Melina Williams from EPA's Office of General Counsel. Petitions for review of DPA's denial of reconsideration of its 2009 endangerment findings should be dismissed for lack of standing, because petitioners have not shown any concrete and particularized injury in fact traceable to a relevant EPA action, as they were required to do in their opening brief. And I'd like to just briefly touch on the types of standing, the types of injury they're relying on. But I also want to answer a question you posed earlier. Is it okay to simply make the assertions in the brief? In most cases, no. It is true that the court's rules say where standing is not self-evident, that the parties are required to present affidavits or other evidence. But this is an action brought by parties that aren't actually themselves subject to any of these rules. And of course, the endangerment finding and this denial are not actions that actually impose emissions limitations themselves. So this is not the rare case where, for example, EPA promulgates an emission limitation. It regulates sources. Someone in that category says this rule imposes compliance costs on us. We have economic harm. We have standing to sue. That would be the type of case where maybe it's self-evident from the record. That is not this case. So looking, for example, at
It is a case where the chain of causation runs through actions of third parties, which is a strong point in your favor.
absolutely.
But isn't it fair to say that as a result of the endangerment finding over the last 15 or so years, there's been very massive and very pervasive set of regulations passed, imposed on cars, on power plants, on fossil fuels? I mean, do we need to blind ourselves to that general point?
There have, in the 13 years since the finding was first issued, been rules promulgated. Some took effect, some obviously never took effect due to litigation. But if anything, I think the fact that we have that much time to look back on makes it even more problematic that the petitioners didn't present evidence. I mean, it would stand to reason that they could have looked at any of these rules that they have talked about today and actually provided an affidavit or some other direct evidence that shows that this hypothesis they're making about how they will indirectly suffer economic harm actually happened. That EPA passed a rule and that it did lead to increased electric bills, for example, for CHEC's members. We don't have that evidence. In the CEI case, which was also brought by petitioners not subject to the order they were challenging, they actually came forward with evidence of the higher internet service rates they complained of and an affidavit that explained how that order likely caused that increase. So it's not impossible at all to meet this burden where the facts support the assertions, but these petitioners did not.
Have you looked at this affidavit in CEI?
I have.
And I have. It's
not personally
not
read.
the most overwhelming.
But I would say it's
There was an increase in prices. There was an economic theory that costs are passed on. And there was honestly sort of a pro forma affidavit that said, yes, costs are passed on. So we're missing that, but.
Fair point, Your Honor. But even just having provided evidence, direct evidence of the increased bills and that it happened shortly after the order is a far stretch better than what we have here. For example, just citing an article that says electricity rates went up in California last year. I mean, I could send you a source just as easily, in fact, I have it, Dallas Morning News, that says electricity rates went up in Texas last year. I don't think anybody would assume that's because the state of Texas adopted a plan to decarbonize its economy. And in fact, the source attributes it to higher fossil fuel prices, natural gas. So this is the problem with relying on speculation as the basis for standing instead of actually introducing concrete evidence. I'd like to talk a little bit about informational injury. The Electronic Privacy Information Center case says that to establish that basis for standing, you have to show denial of access to or deprivation of information that a statute required the government or a third party to disclose to the petitioner, and evidence that the petitioner suffered the type of harm that Congress was seeking to prevent when it imposed that requirement. We don't have here any explanation in the reply where they first mentioned this statute about what creates the actionable right. At least one court, Fourth Circuit, Salt Institute versus Levitt, 440 F. 3rd at 159, has held squarely that it does not create a third-party actionable right to access information or correctness of information. And this court in Mississippi versus EPA, 744 F. 3rd at 1346, considered a claim where a petitioner was making similar arguments about the Information Quality Act to oppose EPA's revision of an air quality standard. And it said basically what they were really just saying is that EPA's interpretation of data was wrong and that a different scientist's interpretation was right. That's not a compliance issue, statutory compliance issue when it comes to information quality. Same is true here. When you look at their brief, pages 33 to 35, all they're really saying about informational injury is that EPA, in their view, didn't have enough temperature data to support its findings. And they say that the data was adjusted by third parties in improper way. But they didn't dispute our response that said all of those adjustments were publicly disclosed. They were transparently disclosed in peer-reviewed literature. They were right there for the petitioners to look at. So this isn't a case of denial of information, deprivation of information. It's just a scientific argument that EPA was. Briefly touching back on their organizational standing over other concerns about fossil fuel availability. I mean, the things that they articulate in their brief are the classic statement of advocacy interest. And the court has held many times that just having an advocacy interest is not enough to create Article 3 standing. You have to show some concrete injury to the individual or to the organization. And if it's an organization, you have to show that the organization used its resources to counteract that harm in some way, other than just advocate. They haven't shown that in this brief. Unless the court has further questions about the merits, we're prepared to rest on our briefs.
Why don't you just briefly address the merits?
Absolutely. EPA in this denial provided 40 pages of careful analysis to explain why it found no merit in the objections to its 2009 finding that increased greenhouse gas concentrations in the atmosphere may reasonably be anticipated to endanger the health and welfare of future generations. It explained why the complaints about inadequacy or invalidity of data were unfounded. It identified problems and deficiencies in the studies that the petitioner submitted that made those studies unpersuasive. And it also corrected petitioners' arguments about what they had called the tropical hotspot and explained that they had misunderstood EPA's analysis and that the things they were saying did not provide any reason to go back and reopen what EPA had found in 2009, particularly when considered in light of all of the additional scientific assessments that have been done for the past 13 years. Those assessments have made EPA's conclusions, if anything, more certain, not less than they were in 2009. EPA rationally determined that there was no reason to go back and reopen that effort.
All right. Thank you.
Thank you, Your Honor.
Mr. Verdugo, you have 2 minutes.
Thank you, Your Honor. On the merits, the first one I'd like to discuss is what we're calling the tropical hotspot, which is a distinctive pattern of warming in the global tropical troposphere that is a key element of the theoretical understanding